my left is Mike and Sue. He will be giving the time signal. To my right, Scott is.
The G's hard.
Sorry. Okay, so we will be adding 10-minute submissions. If you run out of time, ask for permission to proceed. Mike will be giving you signals for 5 minutes, 2 minutes, and 1 minute. And then he will be indicating when your time is up. So if the appellants are ready to get started.
Good morning, Honorable Justices. My name is Paige Diebel, and my co-counsel's name is Fallon Burns. We represent the appellant, Mr. Daniel James Gombach, in this matter. Our friends, Nicholas Balsamas and Andrew McGregor, represent the respondent, Her Majesty the Queen, in this matter. Your Honors, this case is about the reasonable expectation of privacy, and in particular, why the disclosure of electrical use information to the police is a violation of the Section 8 Charter right. Would the court like a brief recitation of the facts?
No, that's not necessary.
There is one issue before the Supreme Court of Osgoode Hall today: whether a search occurred and whether that search was unreasonable. In order to address this issue, myself as well as my colleague have 4 submissions for the court today. The first is the application of the legislative scheme which surrounds customer electrical use information. Second, whether that information falls within the ambit of Section 8 of the Charter. Third, whether or not the electrical use information of Mr. Gombach was abandoned, thus justifying its disclosure to the police. And our 4th and final submission will be an analysis of the policy implications surrounding the exclusion of such information from the protections of Section 8 of the Charter. I will be covering the first and second issues, and my co-counsel will be covering the third and fourth. Proceeding with the first submission, the legislative scheme which surrounds this case is the Electrical Use Utilities Act and the corresponding regulation. Now, it is the appellant's position that
Sorry, counsel, on your stuff. So just to clarify, you're not making any submissions about whether Mr. Gombach had a subjective expectation of privacy in the situation, or whether it was objectively reasonable?
Correct. We are not concerned with the subjective expectation of privacy because it is recognized that that is a low threshold. We are more so concerned with whether or not it was objectively reasonable, and it is our position that it was objectively reasonable for considerations which I will elaborate on further. So the appellant would submit that the obscurity of the regulation is a particular concern in the case at bar.
Is that a reason to ignore it, counsel?
Sorry, can you rephrase the question?
Is the fact that the regulation is obscure a reason for us as justices to ignore it?
Not necessarily that we should ignore it, just that we should take that into consideration when reaching a determination as to whether the police's actions in using the regulation to obtain information and then using that information to indict Mr. Gombach on a criminal charge was reasonable. We would submit that it was not. That the regulation in its initial context might have not implied a higher standard of scrutiny, but once the regulation was used to obtain that information, and that information was passed on to the police, and then Mr. Gombach was indicted on a criminal charge, that is where we have a problem. That is where the action becomes intrusive.
Isn't that the purpose of the regulation, counsel?
We wouldn't say that that's the purpose of the regulation. In fact, the regulation tries to do a legitimate thing. It tries to maintain a presumption of confidentiality, but it goes about it the wrong way. Because what the regulation does is it creates, in essence, a negative billing option. And the appellant would submit that that is relatively problematic to the case at bar, because when we're examining the regulation, there is a degree of ambiguity. And the ambiguity lies within the contradictions between Section 10, subsection 3F, and Section 10, subsection 1. One of them, Section 3F, indicates that unless confidentiality is expressly requested, that the information can be given out. But Section 10.1 says that you have to get the express permission of the customer in order to disclose the information. And the appellant would submit that this is an opportunity for the court to clarify what the legislative intent is.
Sorry, counsel, but you're saying that the police use the regulation to get this information. What's your basis for saying that? My understanding is that what the Crown was saying is that there was no reasonable expectation of privacy, so they didn't need any legislative authorization to get this information or install a DRA or conduct a search.
But the fact remains that they didn't have a warrant to install the DRA. It is the appellant's position.
But they don't need a warrant unless Section 8 applies to begin with, and there's a reasonable expectation of privacy.
We would submit that they do need a warrant in this case, especially when the right to privacy, the right to confidentiality is being infringed upon. We have to look at what the regulation should be interpreted as. And it is our position, and Justice McLaughlin supports this in her reasoning, that it should be interpreted restrictively and in accordance with our constitutional values, namely privacy and security.
Well, what would you have to say then to Madam Justice Deschamps, the court below, who concludes that the consumption that was recorded by the DRA isn't actually private information at all?
It would be the appellant's position that the information which was recorded with the DRA, electrical usage, did convey a personal choice. The personal choice to grow a crop is personal and confidential. And we would submit that it is worthy of protection.
Sorry. So you're saying that the person's choice to engage in criminal activity and grow marijuana deserves constitutional protection?
Not necessarily. The appellant is submitting that the choice to grow a crop deserves constitutional protection because it's not specifically indicated that that cyclical use pattern is consistent only with marijuana. In fact,
okay, so even if that's the case, why does that deserve constitutional protection? Why? So as Justice Opinka said in one of the decisions cited below, Section 8 is meant to protect core biographical information. It's meant to protect information we think deserves protection in our society. Why is that so important? It seems something so peripheral and unimportant. Why would anyone care to say things like that?
the fact isn't whether or not the information is interesting at the time. It's when will that information be interesting in the future? And we would submit that this creates a chilling effect because now citizens are going to have to worry when they subscribe for basic services what information will be considered to be core biographical.
Sorry, can you clarify that for me, counsel? What exactly is this going to chill?
It's going to create an effect where when individuals sign up for basic services, they're going to have to retain legal counsel because they're going to be worried now that even for signing up for something which is considered a necessary service, such as electricity, that they will have to ensure that their charter rights are protected. And it is our position that an individual like Mr. Gombach should not have to go out of his way to ensure that the charter protects him.
But the only reason you have to worry is if you're going to engage in criminal activity or grow marijuana or drugs of this sort. So somebody wouldn't have to worry about what information goes out if they aren't doing anything wrong.
It would be the appellant's position that that would be problematic because we don't know what this will say going forward. It's our position that warrantless searches are unreasonable. Now, if this goes forward, we are saying that warrantless searches are reasonable, and that is not our position at all.
No, but sir, there has to be a privacy interest before you need a warrant for search. And what I think our questions express is we haven't seen any information in this case which has a privacy interest attached to it.
It's the appellant's position that the choice to grow a crop is personal information. But electrical usage can also convey, thank you, other details. So for instance, if a religious observer of the Jewish faith turns off their hydro for a specific amount of time on a specific day, and the police are interested in the information, or they have a DRA installed, now they know that that person is Jewish. That's a personal privacy interest.
Counsel, they can also find out if the person is Jewish if they observe them attending synagogue, which is information accessible to the public standing on a street corner.
Not necessarily, because not every individual of religious faith attends temple or attends a synagogue or attends a church. So it is the principle behind this, the principle that not necessarily what the DRA was used for in this case, but what can the DRA be used for in the future? And at what point do we say, this is enough, this is infringing on what should be protected as a general rule at all times?
Well, is that really true? Because we're we're trying to determine if someone's Section 8 rights were infringed in this case. So really the question is whether or not somebody's privacy interest was infringed here, not what might happen in some other case.
Right. It is our position that not only was the territorial privacy interest infringed upon because the information was obtained from the home, but that the personal and informational components were also infringed upon because, as the appellant has asserted, the choice to grow a crop is a personal choice.
Could I interrupt you, counsel? Can you explain to me how the territorial privacy interest was infringed upon even though the DRA was installed off the appellant's property?
Certainly. Even though the DRA was installed on public property, it was installed on public property to view private events which occurred in Mr. Gombach's home. That's how the territorial privacy interest was engaged. And the intent of the officers in installing that on public property was to view private events. And that's what we need to look at, not on its face, where was the DRA installed? It's where the information was obtained from.
Well, your time is up, but I have one more question.
Sure, may I have a moment to...
Obviously. So you're saying the choice to grow a crop is private information which deserves to be protected in this case. And even if we were to accept that, doesn't the DRA, all that the information they were able to obtain was the pattern of electricity usage over 48 hours, and then see whether or not that is consistent with a marijuana grow operation, not even crops in general. So I'm wondering if you can assist me with that. Where in this information are you saying that it exposes the fact that somebody's engaging in some farming activity or growing crops in general, and not just engaging in growing a marijuana crop?
Right. Well, we would obtain that position on the fact that the DRA is used to produce electrical usage cycle. And the police know that this usage cycle is consistent with the growing of marijuana. And it's from that opinion that we derive our subsequences mission that it could also be used to indicate that an orchid crop was being grown. And although we would submit that maybe some people would be okay with that, the general public at large is not okay with the state going into their homes and obtaining information that they would wish to be kept confidential. And we would submit that unless a warrant is obtained, that this is not reasonable, this is not something which a democratic society should seek to allow. Barring any further questions, this would conclude my submissions, and my co-counsel will now proceed with the third and fourth submissions. Thank you.
Good morning, Honorable Justices. My name is Fallon Burns. I will address whether Mr. Gombach abandoned his confidentiality expectations. I will then address public policy concerns associated with this case. First off is the appellant's submission that Mr. Gombach never abandoned his confidentiality expectations. Under the statutory scheme, he was guaranteed these confidentiality rights. However, we can see that there is an exception that specifically states that unless NMAX or the electrical utility is instructed otherwise, they can share his confidentiality information with an officer or a third party. It is our position that he did not consent to this information being shared because he was not aware of this. It is the appellant's position that whenever legislation creates an option or a negative billing aspect, like my co-counsel addressed, it serves to take a right away from a party. In a situation under a regulatory scheme or a criminal scheme, it needs to be made adamantly clear to that party who is losing a right that they need to know about this. It is our position the appellant was not aware.
Counsel, are we going to place the onus then on the utility providers to right? Whose job is it then to inform the appellant of his rights, basically?
It's the appellant's position that when a party who is interested in subscribing to basic services, such as electricity, that when they are having that consultation or that meeting to subscribe to the services, to sign off on that contract, at that point, the electrical company serves the party with a waiver, as well as a large package of information explaining how the process will work, how billing will work, how the consumption process will work in general.
And you're asking the court to read that into the regulation?
Yes, Your Honor. This needs to happen because in a regulatory scheme, rather, I retake that comment, rather in a criminal scheme, it is decided that a party needs to be aware of any deadlines, of all notice, of all disclosure, when they are losing a right, when this information is forwarded, because Section 7, life, liberty, and security person, is at bar. In a regulatory
Sorry,
scheme...
Counsel, I didn't realize that either the regulation or Section 7 were at issue in this trial.
Sorry?
I don't believe that either Section 7 of the Charter or the regulation in question are an issue in this trial.
I'm not suggesting that there is life, liberty, security person is in jeopardy. Rather, that these regulations and that law in general that pertains to criminal law does jeopardy. That Section 7 does become a jeopardy. And so when we're dealing with the regulatory scheme, although Section 7 is not a bar, there is jeopardy. There are offenses.
Sorry, but what I mean to ask is that I did not, so I believe that the regulation itself is not at issue in this trial. So I don't really understand what the role of these submissions about asking us to rewrite the legislation essentially are in this appeal.
I'm sorry, I misunderstood your question. You're right. What I mean to say is, it's not the regulation that is the problem, it is the actions of the party and Max by not notifying him that his rights could be taken away, because it is not reasonable to expect an average person to know the particulars of an obscure, as my co-counsel has stated, legislative scheme for him to be found to have rights taken away without being aware of it, and for him to face offenses or, we'll say, consequences of such.
So if I understand correctly, your submission is that because it's an obscure legislation and because the electricity company did not bring it to his attention, therefore it is not a reason for saying he waived his privacy interest in this case.
That's precisely what I'm saying.
But is that submission predicated on us accepting that this regulation is criminal in nature and not merely regulatory?
Not necessarily. It is the appellant's position that although it is regulatory, the police used it to investigate a criminal scheme. While no charges were pressed at this point, they were using it to attain evidence. And because they're using it to attain evidence for a criminal scheme, he needed to be at least aware.
Counsel, isn't the purpose of the regulation to allow peace officers, law enforcement officers to access this information? What conceivably could be another purpose for the regulation if it's not to investigate criminal activity?
That is correct. However, it is still very important that a subscriber or Mr. Gomba was aware that this could happen. Because he was not aware, rights were taken away from him unfairly.
Well, I'm sorry, counsel, but courts have found in the past that in hiring regulatory schemes like this, that you're supposed to be aware of the things that you're signing into. Like, is it then that like the electrical company has to walk the person through every sort of thing they could trip over?
Not absolutely everything. There's a threshold to how much notice they are required to give. And as I have stated that in a regulatory basis, the amount of notice that is required is lower than a criminal basis, but there still needs to be notice, and it is our position that he was not given enough notice.
So, okay. So supposing we accept this submission, your submissions on Section 8, are you going to say anything about whether or not there was a valid warrantless search in this case under the Waterfield test for dead men, for instance?
I'm sorry?
So are you making it, so even if we accept that Section 8 was engaged in this case, that he did not waive his rights, the police could still carry out a warrantless search under their common law rights. And are you making any submissions to that?
No. I'm sorry, may I have a moment to refer my document? Perhaps to address the idea of the Waterfield test in case. From what I understand of the Waterfield test in case, it is that whether such conduct, whether it is in the general scope of the duty, involve an unjustifiable use of powers associated with the duty. It is our position that this did perceive to be unjustified. They did use additional powers, while it might not be out of their, well, the statute or the regulation allows it because he was not aware of it and did not consent to it, as the regulation calls for, both in under, it was section, I refer the court, to paragraph 147 of the decision. And specifically, it states that no official may disclose information to any purpose without the consent of the person who is the subject of the search. That is consistent with that of the regulation that takes Mr. Gombach's rights away. And Justice McLaughlin further wrote that this general rule must be read in restrictively. Thank you.
Well, isn't this also, though, it also says exactly in 147, though, that section 10(3)(f) is the exception to this rule, which is exactly the aspect that my judges have spoken of the idea that there is the exception that they can go to and give this to the police.
I concede that. However, it's still the appellant's position that he did not consent to this because he was not aware enough, was not given enough notice. Therefore, he did not abandon his information at any point. Referring to public policy, this decision is highly important because if we allow this decision to go forward, we send the message that obscure statutory schemes and obscure contracts, as it were, for basic services, let alone alternative services. Thank you. It is okay to give it to write abstract contracts and expect average people to be able to navigate them. It almost entraps average people, and in order for them to search to.
You suggest there's wrongdoing on the part of the utility company?
I'm saying that there's merely a power imbalance, and that it becomes unfair to an average citizen who requires these services. These are basic services. To expect them to have to bring forward a legal counsel with them to sign on to basic services is unreasonable, because lawyer fees are very expensive for an average person, because lawyers are not always available at a moment's notice to either answer a phone call or to have to read over a contract.
Counsel, but why would they need legal counsel? Like, looking at the regulation, maybe I'm biased, but it doesn't seem like it's that hard to read, and that a person reading it could understand the consequences. It's basically saying that unless you say otherwise, the company's free to share your information. I know you're out of time, but you can answer the question and conclude.
Okay. I concede that it is clear and unambiguous. However, this sort of term might be buried in a contract on the very last page. It might be buried in a footnote. If we allow these sorts of things to go forward, where it is not plain and obvious, and in the attention of the person who is signing off on this contract for basic services, it is unreasonable for an average person to find that, and it sets them up to be taken advantage of. Therefore, they would need the lawyer in order to do a background check of what the consequences of the contract would be, what the statutes that regulate the contract would be, in order to make sure their privacy is guarded. Barring any further questions from the bench, this concludes my submission.